Welcome to the Rozanne On Demand CFPB video series, featuring Ontario System's Chief Compliance Officer, Rozanne Anderson. Widely recognized as a leading authority on collection-related compliance, Rozanne leads Ontario System's corporate efforts in response to the CFPB's launch of compliance examinations in the ARM industry. In this ongoing video series, Rozanne takes a deeper dive into the entire regulation, helping you make sense of the new rule and what it means for your agency. Before we get started, please take a moment to review our legal disclaimer. The information shared today is not legal advice. Please consult with your own independent legal counsel before making any business decisions regarding the use of this information.
Welcome to today's video podcast covering Regulation F. Today we are going to focus our attention on the section 1006.18, false, deceptive, or misleading representations or means. This is not a new concept to debt collection. The Fair Debt Collection Practices Act has a very specific section addressing what is false, deceptive, or misleading when it comes to collecting debt. But the CFPB has taken the time to expand on what exactly is meant by a false, deceptive, or misleading representation to a consumer or means of communication with a consumer. So the general rule is that a debt collector cannot use any false, deceptive, or misleading representation or means to collect a debt because it's considered to be an unfair practice overall. So this is just a codified example of an unfair practice. Examples of misrepresentations that are illegal under the law would be, for example, any statement or implication that the communication from the debt collector is really authorized by the state, by the federal government, anything that would give the consumer the impression that you're actually an agency of the state. And that's considered definitely to be a misleading representation. Another example is if the debt collector suggests that it is basically a type of consumer reporting agency. Again, this is almost harkens back to some practices of days long gone, but nonetheless, it remains front and center that the CFPB is telling us they are very concerned about how debt collectors represent and present themselves to consumers and persons as they collect debt. They also talk about a few other important examples. For example, you can't threaten them. You can't threaten them with the idea that they will be committing a crime if they do not pay the debt, or that you're going to repossess the item when you really have no legal basis to do so. You can't represent that the documents you're going to be sending them are legal process documents. All of that is you are not to basically create a false sense of urgency around the collection of the debt. That's simply not true. Now, don't confuse anything that I'm saying today with the fact that you can make true statements to consumers. Everything I've covered so far under Regulation F and the FDCPA would be examples of where they're trying to curtail any false statements or statements that may be misleading, kind of a half-truth as well. So the most significant section of this whole provision, though, centers around the fact that debt collectors cannot falsely represent the character, the amount, or the legal status of any debt. Now, we've heard those words for so many years that I think it kind of just, we don't even pause to think about what they mean anymore. But they're becoming more and more important. So you can't misrepresent the character of the debt. So if the debt really is it was discharged in bankruptcy, for example, you can't suggest that it was not. If the debt really is time barred, you can't suggest that it is not time barred. I mean, that's the kind of the concept around character of the debt. The amount of the debt is you have to actually tell the person exactly how much they owe. Now, the new validation notice, Model Form B, makes it very clear how concerned the CFPB is about itemizing any charges, fees, costs, interest, etc., that have been added to the principal amount of the debt since the itemization date. But for purposes of our conversation today, suffice it to say that the amount of the debt is extremely important. The accuracy of that amount is important. And when, for example, you lay out a payment plan for the consumer, let's say it's a secured payment plan, secured by a pre-authorized electronic funds transfer, even secured by a series of credit card charges that you are going to make because you have prior authorization to do so, you cannot misstate the amount that you're going to debit or charge. That has to be an accurate statement, accurate representation to the consumer from the get-go. Also, a debt collector cannot represent or imply that the non-payment of debt will result in the arrest of the consumer or any of their family members. Now let's turn our attention to what the Regulation F and the CFPB expects of debt collectors with regard to collecting debt under this section prohibiting false, deceptive, or misleading collection means, in other words, methods. So the rule states that a debt collector must not threaten to take any action that cannot legally be taken or that is not intended to be taken. And they cannot communicate or threaten to communicate to any person information the debt collector knows is false. So let's pause for a second. What that means is that, for example, when collecting any debt, you cannot threaten that you are going to take legal action or that anyone else is going to take legal action in the future, meaning your outside counsel, if in fact that is not true. You can't say, well, I bet this is going to legal action. I bet we are turning this over to our legal department. I mean, you can't suggest, imply, or say anything that will cause the consumer to infer they're going to get sued for this, when in fact that isn't true. If it is true, that's a different story. That would not be a false statement in any event. So remember that. They're very concerned about those false threats. Also, if you have a legal department in your collection agency, if you have a pre-legal process in your collection agency, be very careful to check how those people answer the phone. Let's say you transfer the consumer to the legal department of your agency. I'm not a big fan of the term in the first place, but this is not about what I think about legal departments within a collection agency, a traditional collection agency. But this is a warning or a recommendation to be very careful about how that department represents itself to your consumers. Because if in fact their account is not being prepared for legal action and being sent to an attorney for legal action, or unless you're in a right of assignment state, in which case things work a little bit differently. But nonetheless, if you're not really on the path to legal action, you cannot do anything that would cause the consumer to believe that their account is in suit or soon to be sued out. Another example of a false or form of communication or misrepresentation of collection would be if you fail to identify an account as disputed when it is disputed. And what this means is that if, for example, you're a data furnisher and you report accounts to a credit reporting agency, if the consumer does one of two things, if they dispute the debt under the FDCPA, or if they dispute the debt, obviously under the FCRA, in either case, you must report that item as disputed on the credit report, no matter where you are in the collection process. If you find out it's disputed before you even credit report, when you load it up send it to the credit reporting agencies, it enters the system as disputed. If, for example, it's been settled in full or paid in full, and it's the 90-day period after payment in full or settlement in full has occurred, and you're in that 90-day reporting period with the CRAs, if the consumer disputes it at that point, you need to flag that item as disputed. So regardless of where the account is in the credit reporting process, once you know or should know that the account is disputed, you must flag it as such in the credit report. So be very careful of that. Also, this might be a good time for me to remind everyone that many of you who are data furnishers understand that you have to have a unique investigation process to follow up on disputes about the consumer's credit report or items on their report. I want to emphasize the importance of having a parallel not identical, but a parallel investigation track established under the Fair Debt Collection Practices Act and Regulation F to follow up on disputes under the FDCPA. These are not one and the same. The disputes are unique. The law of the Fair Credit Reporting Act versus the Fair Debt Collection Practices Act imposes unique requirements on you in terms of investigation, and it is a hot button for the CFPB in terms of its investigations and enforcement actions. Other areas that provide us with examples of false or deceptive means of communications with a consumer in connection with the collection of a debt pertain to disclosures that are required. Everyone knows that in an initial communication with a consumer, that means the first time information about the debt is disclosed, not a limited content message, for example, but in the initial communication with the consumer, the debt collector must provide the full Miranda warning. I'm not saying mini, I'm saying the full Miranda. This is a communication from a debt collector, and all information obtained will be used for that purpose. That must be included in the initial communication. The CFPB tells us in the new rule that if that initial communication is oral, like a phone conversation, for example, then the debt collector has a duty to provide that full Miranda warning one more time when it first communicates with the consumer in a writing. So if we have the oral verbal communication today, and I send out a letter within 5 days of this initial communication, this initial verbal communication, that letter must include the full Miranda warning. Due to the complexity of this new requirement, let's take a moment and review the provision as presented in Regulation F. Disclosures required. Paragraph 1. Initial communications. A debt collector must disclose in its initial communication with a consumer that the debt collector is attempting to collect a debt and that any information obtained will be used for that purpose. If the debt collector's initial communication with the consumer is oral, the debt collector must make the disclosure required by this paragraph again in its initial written communication with the consumer. Paragraph 2 goes on to explain, in subsequent communications, each communication with the consumer subsequent to the communications described in paragraph E1 of this section, the debt collector must disclose that the communication is from a debt collector. And the FDCPA and Regulation E makes clear there is one exception to these disclosure requirements. Paragraph 3. Disclosures under paragraphs E1 and 2 of this section are not required in a formal pleading made in connection with a legal action. And that's why we all have to understand and appreciate that in any communication subsequent to the initial communication, as I just explained, any communication subsequent to it, all you need to do is reveal that you are a debt collector. You don't have to say anything more than that. So for example, if you are ABC Remediation Service or ABC Liquidation or ABC Financial Services, something like that. In those examples, the name of the company does not reveal that you are a debt collector. That means for those kinds of agencies with those kinds of names, every one of their communications subsequent to their initial communications must include a descriptor indicating they are a debt collector, meaning it would be ABC Liquidation Company, a debt collector, or it would be, by the way, I'm not drawing a conclusion about whether liquidation company is or is not a reference to debt collection. I'm using it as the example that it's really not clear on its face that you're a collection agency, as opposed to ABC Collection Agency. Those organizations do not have to include any reference to debt collector or debt collection in their subsequent communications with consumers, because their name, which must be included in the communication anyway, their name reveals they are a debt collector. So keep that in mind, because you are going to need to walk away from the practice of just putting the full Miranda warning in every communication, because, well, from the standpoint, well, how does it hurt? Well, it hurts when you're going to get into text messaging. It may even create some, well, emailing, it shouldn't be too much of a problem, but text messaging would be a good example. Now, there is an exception to some of these disclosure requirements regarding the full mini Miranda and the subsequent disclosure requirement that you are a debt collector. And that's when it comes to translated disclosures. This is a new requirement. The CFPB tells us in Regulation F that a debt collector must make the disclosures required in the initial communication and the subsequent communication sections of this regulation. You must make those disclosures in the same language or languages used for the rest of the communication in which the debt collector conveyed the disclosure. Any translation of the disclosures a debt collector uses must be complete and accurate. So that means that if, for example, this is the one that I think is going to catch people. If, for example, you have an inbound, when consumers are making inbound calls to your agency, and this is the message they hear. You have reached ABC Collection Agency. This is the communication from a debt collector, and all information obtained will be used for that purpose. Well, obviously, when you transfer anyone to a live collector, what they're saying is that you disclose the full Miranda in English. So now, when you transfer the person to a collector, a live collector, then that communication needs to be in English. Conversely, if you have one of those IVR response options available to consumers where you press 1 to receive information in English, 2 for Spanish, 3 for whatever else you want to include, in that instance, what will happen is if the consumer presses 2, if you say, I don't speak Spanish, but if I did speak Spanish, what I would be saying is that in English, if you'd like to communicate in English, press 1. And then Spanish words, meaning if you'd like to communicate in Spanish, press 2. Because those words that I can't say because I don't speak Spanish, because those words to press 2 were in Spanish and included the statement, this is a communication from a debt collector and all information obtained will be used for that purpose. When I press 2, I have to land and be assigned to a Spanish-speaking debt collector. Because whatever language the full Miranda was given in that example, you must continue to communicate with that consumer about the debt in that foreign language. Thank you for joining us today.
Be sure to join us next week for an exclusive webinar where Rozanne will recap the topics she's covered. She'll be joined by special guest John Bedard Jr., managing attorney at Bedard Law Group, and together they'll address some of your most pressing CFPB new rule concerns. Register for the webinar today at the link provided below and submit your questions for consideration. Thanks again for tuning into this week's episode of the Rozanne On Demand CFPB video series. As always, be sure to visit the Ontario Systems website for more exclusive events and information regarding the 2021 CFPB new rules.